Hi, good morning. Good to see you guys. Thanks so much for having us. I'm going to speak to you a little bit later about some of the things that seem to be areas where sections have a lot of questions, but we're going to lead off with Braxton talking with you guys today about what the Legislation Committee does and the bar's legislative process.
Thanks, Gypsy. You all have a very long day, and I've got a limited amount of time. I'll say about when we start talking about legislative and political activity, it's probably a seminar we could spend a day on. You all don't want to do that. I'm going to do the best I can to kind of hit the high points, but I can't stress to you all enough how much scrutiny there currently is on mandatory bar involvement in legislative and political activity. The case law that we're seeing around the country, attacks on other mandatory bars by members and federal court filings. And this is a particularly concerning issue. If we want to continue to operate as a mandatory bar, we're going to have to be vigilant and comply with the developing law. And we're working hard to do that. And I will speak specifically about standing board policies and how section leadership can get involved and your sections can take positions and what process you go through. But I want to start by talking a little bit about the law we are seeing and the law that governs our mandatory bar activity. Many of you may have heard about the Keller case. That's a 2000 case, Supreme Court case. It involved implications of a particular mandatory bar at that time. And we've all here in the state have tried to follow what we believe were instruction from that case. But there were a lot of holes. A lot of things were unresolved and a lot of questions remain. And there's been other suits and other disputes that have followed. Most recently, in the case that we talk so much about now, is a Janus case, a 2018 case, Supreme Court case that involved attack on mandatory union membership. And we have been closely analogized, we being mandatory bars, to union membership. And so that case has been deemed to apply to our activity and our section activity. And so we're watching closely, of course, what's developed from Janus. And there have been, really in the last 2 years, we've seen a great deal of additional litigation. I mean, there are people out there looking, it seems to be, to attack the mandatory required membership in bar activities around the country. And I'm going to speak specifically about a couple of those cases. One of them is the McDonald case, which is a Fifth Circuit case involving a dispute regarding activities of the Texas bar. And that case is still ongoing. And it's an interesting case. And though it's not binding on us here in Florida, it is one that, again, I think that because of the activities, the social justice type activities and positions taken in the Texas bar is, that case is not over yet. But I think that the Fifth's initial look in a preliminary motion, perspective, I think it's very instructive and again, something we're trying hard here in Florida to comply with. I will tell you that, we got good news earlier this year. Again, there's a series of these cases, not just in the Fifth Circuit, but others as well. And the Supreme Court refused to accept cert to take a look at what's actively going on. We thought that, that initially on its surface looks like it's good news. The Supreme Court's not going to be more active in evaluating these issues, but there's a concern that, the issues that percolated in the petition for cert to the Supreme Court that, again, were addressed earlier this year were interlocutory type orders and rulings. And I think there's certainly a consensus that the Supreme Court's waiting for a more fulsome record in order to take up and further clarify where the line is for mandatory organizations, like in this case, the Florida bar, or what we can and can't do when it comes to political, legislative type activities. And so, again, we're watching it very closely. We're very nervous about it. This just very recently, this month, the Louisiana bar had a success, and I think it's very well written order. I think, instructive for us. And I think it goes to the heart of what I'm saying to you now, which is there's a lot of attention on this issue. But I want to talk about that case because I think it's the most recent thing we've seen. This is the Boudreaux versus Louisiana State Bar Association case. And we got, a final judgment was issued, earlier in August in that case. And the court went through, of course, looking at also, all the way back to Keller, but more recently the Janus case and the McDonald case, the Fifth Circuit case I talked about, looking at kind of where the status of the law is and what Louisiana Bar can and can't do. And I think what's most important and most relevant to the discussion about what sections should be worried about and what the Florida Bar is worried about is the non-germane activities. And that's the term we see talked about a lot in the McDonald decision is what's germane to what the bars is tasked to do and what's not germane. And again, we all have to remember that, we're a professional regulatory organization set up by the Florida Supreme Court, that being the Florida Bar. We're not a social justice organization. And this is a comment from that case talking about what is germane, what's not germane. And I'm going to read this first paragraph, although I know you all can read, but I think it kind of leads to the point I'm trying to make. And the court in Boudreaux, citing McDonald, said that for activities to be germane, they must be necessarily or reasonably incurred for the purpose of regulating the legal profession or improving the quality of legal services. So, what does that mean? Obviously, what it doesn't mean is it doesn't mean a position on gun control. There's no position that will be related to gun control that will be related to regulating lawyers. And that's a gross example, but I think it highlights the point that we're making here. We as a bar, and even when we start talking about voluntary bar groups like sections, can't take positions which are socially, politically controversial that aren't related to what we do. In this particular case, what was at issue, and ultimately, why did the Eastern District of Louisiana say that the Boudreaux claims weren't good claims, that they found that they were, in fact, germane activities. The complaints in that case, just to show you how, what the level of attack on mandatory bar membership is right now, a member in this, Mr. Boudreaux, complained and filed a federal court lawsuit stating that he thought he should not have to be a member of the bar because the bar was tweeting things like, let me give you some examples specifically. Tweets and notes on the website for the bar touting the benefits of broccoli, the benefits of walnuts, urging readers to get fitness goals and work out 3 times a week, touting the benefits of sunlight and snacks before bedtime, and promoting good health. And let me say to you, I think we all certainly would agree. One part of regulating lawyers is ensuring lawyer health and mental health, and that has been a key focus for the Florida Bar in recent years, trying to assist lawyers, and particularly dealing with COVID and the follow through of COVID and depression. Working with those are important things. Those are important for the profession and important for delivery of legal services. And so, and the court found that, and so they found that these type of communications and activities were clearly germane, and the claims didn't stand up. But where this is, I consider a win or a victory for mandatory bars. I think it highlights where the line is, because when we start taking positions that are, we individually and frankly collectively, may feel like a social position needs to be advanced, and it makes the sense it's better for society and better for our country. It's not our job, and we have to find other organizations within which we're involved to take those positions. And we have. And so, what is a voluntary bar group? And that just kind of rolls into. And I know I'm talking too long. Gypsy, give me the hook when I've got to stop talking again.
You're good. You're good.
What is a voluntary bar group under the standing board policies that govern the Florida Bar and frankly govern section activities? A voluntary bar group under the standing board policies is an organization like sections. Sections are voluntary bar groups because you have to opt in, and usually there's a fee associated with membership in your various section organizations. Those are voluntary groups, and the result is There are things sections can do, and I'll talk about a little more in a moment. So positions you can take that are, frankly, position that the bar itself can't take. So there is more latitude in what you can do. However, there is a limit to it because you continue to be a part of the Florida Bar, and we continue to be an arm of the court, a quasi-judicial government organization tasked primarily with regulating lawyers. And so we have to be careful. And so this, what we have, what you're seeing now is on the screen, Gypsy sharing sort of a summary of what rules govern your potential political legislative activity. And Standing Board Policy 9.11, defines what a voluntary bar group is, and also what you have to do in order to take a position. And ultimately, I'll tell you, there's a lot to this. There's some meat on the bone here. The good news is you've not got to memorize it. Today is to kind of remind you that you have these responsibilities, but you've got staff liaisons who are there to help you and to help you through the process and make sure we comply with the rules. We don't run afoul of the Supreme Court and ultimately the U.S. Supreme Court and get dinged. Go to the next page if you would. And the flow chart I think is really helpful.
Oh, okay, sure.
I'm sorry. I'm instead of reading.
No, that's fine. There we go. That one? Yes.
And so this little flow chart, this is a good, and we'll provide these to you if they've not already been provided. I think it's good and helpful, to remind you what the process, is. The first step is to request the opportunity to take a position, and there's a formal line. Again, your section liaisons can help you, with this process. And what type positions are we talking about? It's not just supporting a particular piece of legislation. It can be providing a white paper on legislation, which we think sometimes is a neutral position. We're lawyers and advocates. Whenever we write something, we write it with a spin, whether we say we do or don't. White papers are included. It also includes things like articles, whether it's for the Florida Bar Journal or other publications. Any kind of position that's put out there and it's purportedly taking and credit is given to your section or to the Florida Bar, all of these activities would be regulated by the applicable standing board policy we're talking about. Go, if you would, to the next slide. So this is kind of the sort of checklist of how we evaluate it. First, is it within, when we receive a request, the legislation committee receives a request from a section, to take a position. One of the critical issues is the position you're trying to take within your jurisdiction or something, laid out in your bylaws you would support. And I'll note that this, by the way, I think this also goes to the overall issue when you're evaluating whether it's a position, the section and or the bar is going to be involved with. Look at, we have organizations like the trial lawyer section, which takes very few legislative or political activity type positions. They're involved. They're in Tallahassee, and they advocate for courthouse funding and ensuring access to courts. And then we have other sections that are more involved. And I use reptiles and the business law section are much more involved because they're focused on a particular group of either businesses or lawyers, and then they have a more direct interest in a particular piece of legislation. So the first issue is when you ask the bar for permission to write a white paper or to take a position with the legislature, is it something that's within your section? Is it a business law issue if it's a business section coming and asking for it? And then the next issue is it beyond the scope of the Florida Bar's activity, or is it within the scope, and is it consistent with a bar position on the issues? And this relates to it. The evaluation there from the legislation committee and ultimately the bar's position is this something that the section can do that the bar otherwise couldn't do, and is not inconsistent with an overall bar position? And then lastly, and this is the kind of, it's in blue, but maybe I might would have put it in red for a color diagram. And it says, does the issue not have potential for deep philosophical or emotional division among a substantial segment of the bar's membership? And that's where we get really political, and this is the one where we don't want you getting the bar in trouble. And this is the one that can be most controversial. It's a position that a section wants to take, apt to be controversial, not only among your members, but among the bar itself. It is a particularly political position. And if it is, and it potentially divisive, well, it's not within or frankly not germane to what a mandatory bar, should be involved in. It may be something that another lawyer organization that's not part of the mandatory bar might take. The Florida Justice Association, the Jacksonville Bar Association, the Florida Women Lawyers Association. I mean, there are a number of truly voluntary bar groups who aren't voluntary bar groups under the standing board policy definition. They're outside the Florida bar. They're independent of the Florida bar. They're not managed. There's no oversight from the Florida bar. They can take those more politically divisive social issues and take whatever position they want to on them. But the bar and its sections have to be careful because, again, of the case law I alluded to earlier. I know I'm running up on my time limit. And I know I've thrown more at you that I probably could have taken a day giving you what I've given you in 20 minutes. I want to end by saying I want to encourage you all to talk to your section liaisons if you have questions about these issues. I'll invite any of you to contact me if you'd like to talk to me about it. I'm a little bit of a nerd when it comes to some of this, the case law and what's going on. I'm watching it every day, and it's particularly interesting to me. Gypsy is far more astute and educated than I am on it. I'm sure that she would welcome a phone call from you as well. But I'll end with cautioning you to be careful about it. Be cognizant of the fact that the bar is under substantial scrutiny when it comes to political activity. And we're going to be taking probably a more close look at your request for political and legislative activity than maybe historically the bar has. And it's because we're trying to protect the job that the bar has been tasked to do and want to maintain that opportunity and frankly the fact that lawyers are regulating lawyers and not someone else. And so it is a big issue. Again, I welcome any questions from you now or later offline, and I'll stop talking, Gypsy.
No, it's all good. I was just going to add to what you were saying by sharing part of our website so that everybody knows what's out there as support tools. So let me get over to that really quickly. Excuse me. Let me get rid of this. All right. So are you able to see the website now?
Yes.
Okay. On the website, I just wanted you all to be aware that if you're ever interested in what all the legislative positions are, it's out here under membership services, and then you can go to our master list of legislative positions, and you can see on the screen that we have bar-wide, and then we have it listed by voluntary bar group or sections. So all of that is out here for you all to look at anytime you'd like. As far as the process for sections to use, it's right here where it says how to submit a request. You can click on this and it takes you to the online form and you can fill that out. And when you submit it, it comes directly to my office and it's just an online process, next page, next page. But if you're not ready to submit yet, we have right here this worksheet where you can download a Word document and it gives you a convenient tool to kind of work with people if you're more of a paper starter of kind of things. So that's here. And then the other really great thing is here where it says see step-by-step instructions. It will take you to the Council of Sections page. This is also there where we have, this is the whole process with some pictures to walk you through that process of how to do that, where to go, here's what happens. And so we know it's a cumbersome process, kind of overwhelming at times, can be onerous, but I wanted you to be aware that we have those tools out there on our website for you to use. And you're more than happy, seriously, I'd be more than happy to field any calls or questions that you have. Excuse me, that you have. Were there any questions about the legislative process for Braxton or me? Is there anything that we could discuss further for anyone?
So I see one in the chat, Gypsy. I'll read it.
Okay.
And it's from Ms. MacArthur. And it says, since section membership is voluntary and no one is forced to join, can you point to any case law that prohibits advocacy from a voluntary group? Or is the bar just extrapolating from cases regarding mandatory bar membership? That's a really good question. And I'll submit to you, I cannot point to a case where a bar has been punished and or lost its mandatory status because of something a section did. However, this case law is in flux. We're expecting more and more rules coming down. And I will tell you that the Florida bar has already been used in briefing in some of the ongoing cases, section work. And particularly, you all, some of you may be aware that the business law section created a rule, I guess it's 18 months ago now, which required certain diversity requirements in connection with any CLEs that will be sponsored by the business law section. And that ultimately, the Supreme Court ultimately said, we can't do that. That's an inappropriate thing, and that's stopped. But in the midst of that, one of the cases, and I think it was the case out of Minnesota, Gypsy, and I'm going to forget the name of the case, but an amicus brief that was filed in that case talked about the Florida bar taking social justice positions and mandating certain diversity components with regard to CLE as a justification for getting rid of mandatory bars in that case. Now, that was something a section did, and of course, a clarification could have been provided. There was no decision in that case based upon that comment. But the point is, and to be clear, the bar sections are part of the bar, and to some, and the bar has some oversight for bar sections. The criticism will always be that the bar sections are staffed by bar employees, and bar employees are paid in part from bar dues. I mean, there's a connectivity that we can expect and do expect. The fact that sections are part of the bar, although they're voluntary, I mean, they're one step removed. They're still part of the Florida bar, and they can't. They are positions that the Florida bar sections are not going to be allowed to take because they will be, they're part of the Florida bar. And we are an arm of the government and not a truly independent voluntary organization as a whole.
I also got a question about, let me get over to the chat that says, could I talk about the process to get a lobbyist approved by the Board of Governors? And this person said that they had looked at Standing Board Policy 9.51 and ding, 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 you got that. So really it's as simple as the section makes the decision, and my office, we have the standard legislative advising agreement form, and you fill that out and you send that to us. And Joni, who works in my office, she will get it on the agenda for the legislation committee to consider. And then if they approve that, then it goes to the board for approval. So that's it in a nutshell. Braxton, I didn't know if you wanted to say anything on that, or if there was anything else anybody wanted to know about that process in 9.51?
I think that's great. Thank you.
Okay, cool. We just reviewed several of those at our early July meeting. So it's a fairly easy process. But if there are no other questions on that, let me get to no more legislation questions. We're all good? Okay, then let me share one last thing. So What you'll find in the materials that I gave to Chase and his folks yesterday really was just kind of a short description of everything the general counsel's office does. And one of the things that we do is process amicus curiae briefs and comments and responses and rules cases that are in the Florida Supreme Court. And this just kind of lays out for you in an easy form. It's in the handbook that you'll get if you don't already have it. These are the two standing board policies that are responsive to your desires to file such documents. And the third, number 3 on page 2, really talks about what that process is. And it really involves, it's as simple as your section makes its decision to file, we'll just say, an amicus brief, and you have to notify Josh as the executive director that that's your intent. And if you don't have it ready when you notify him, you need to have it ready pretty soon. You'll need to submit a draft of what that filing will be. And then Josh will talk with the bar president and take what other action is needed, and then you'll be notified whether that's okay to file or not. Same basic process in the rules proceedings. So I wanted to just present that to you all today. I don't know if you'll have questions on that, but that seems these two areas are big questions that we get all the time about how to do that and who to get what to by what time. Is there a question or any discussion on this? Okay, good enough. And the only other thing I was going to point out, what Elizabeth said earlier applies in my area as well. My office exists to help you, and we get questions a lot from staffers. You guys have some great people staffing your sections, and I get a lot of questions about raffles, games of chance, that kind of stuff. I've worked with your staffers over the years to kind of fine tune that and provide some statutes and whatnot so that you guys can read that when you have questions. I also get questions about copyright using pictures and writings and various things and promotional items for events and whatnot. So, I mean, we're here to support you. Anytime you have questions, you're welcome to channel those through your staffer. You're welcome to call me directly. However it is that we can help you guys, move forward on activities that you want to be involved in, we are happy to help with that. And really, that's, I think, all we have, unless you have other questions that I can help with. If there are no other questions, I will tell you thank you so much for letting me and Braxton speak to you guys. And if you have other questions, just call us or email us offline. Thank you.